Welcome to U.S. and Texas LawShield Facebook Live session from the news desk in Houston, Texas. I am Sam Malone. Thanks for joining us. Obviously, we have to talk about the horrible, horrible shootings and murders that took place at a small church by San Antonio, Texas. But there's a lot of rules. There's a lot of regs. There's a lot of things went wrong, things that did, that went right. And we have to talk about it so that you know what to do if, gosh forbid, you're in that situation. As always, you can leave your comments and leave your questions right now on our Facebook page right here at Texas LawShield. Edwin Walker standing by, who is one of the independent program attorneys at U.S. and Texas LawShield. He is our go-to guy, joining us via Skype today. Attorney Walker, how are you, sir?
I'm doing great. How are you, Sam?
Excellent. It was really weird we were enjoying the weekend, and the story popped up that there was a horrible shooting at the First Baptist Church of Sutherland Springs in Texas, a little tiny town. A crazy gunman walks in there who's been identified as 26-year-old Devin Patrick Kelly. 26 people dead, murdered, 24 others injured. He walked in and opened fire with what they're calling a military-style assault rifle. According to reports, he was then shot by the good guy across the street, a 55-year-old gentleman by the name of Stephen Williford. The gunman died after a car chase with another man. It was the two good guys versus the bad guys. Let's get the actual facts, Mr. Walker, when it comes to carrying guns in houses of worship in the state of Texas. I have an LTC license to carry. Am I or am I not allowed to walk into a church based on the rules and regs with my gun on?
Right. Well, keep in mind, we always start with the premise that a church is private property. And so as the occupier of a piece of private property, they can do whatever they want. And with regard to an LTC, that is true as well. Even though churches are listed in the areas as premises that are prohibited for LTC holders in Texas Penal Code 46035, they are only off limits. They are one of the four places that are only off limits if the church has properly given a 30-06 or a 30-07 criminal trespass notice. So this can be done orally, as if there were, if there are ushers at the front and they could stop license holders and tell them verbally that they're not allowed to carry. Most often this would be done through signage, though. And if the person had a criminal trespass sign that complied with the exact terms of Texas Penal Code 30.06 and or Texas Penal Code 30.07, then a license holder would be prohibited as applicable. If they had both signs, the license holder couldn't carry their handgun at all. If they just had a 30-06 sign, they could carry openly but not concealed. If they had a 30-07 sign, they could carry concealed but not openly. And so this is totally up to the church. It's completely within the church's discretion to do this. The only possible exception would be, I know that there's a lot of churches that have rental agreements with school districts. They will hold church at a school, either in the auditorium or somewhere like that. I've seen it several times around here. If the church is renting a place that is in fact owned by a school district, then school property is a prohibited place 24 hours a day, 365 days a year. But it's just the buildings. So I should add that. So if a church is renting a part of a school building to hold their church service, all firearms are prohibited by statute. But otherwise, with a piece of private property, the church itself controls who can come in and not come in with a firearm.
Edwin Walker, independent program attorney, U.S. and Texas LawShield. We're doing our Facebook Live newscast today, obviously, with the breaking news about what happened at the First Baptist Church of Sutherland Springs in Texas. What was the reason? Why did they pick houses of worship as places where you can't bring a gun in, for the most part? That was one of the four places listed. It's an awfully soft target, Mr. Walker. There's a lot of people who have hatred, towards certain houses of worship. What was the basis of that?
Well, you have to go all the way back to when the concealed handgun license law was written in the state of Texas way back in '95. And you have to look at the legislature then. Keep in mind that the landscape of concealed handgun licenses was fairly new. It was certainly new to Texas. And a lot of the places that were listed in there, the places that are in 46035, professional sporting events, amusement parks, hospitals, churches, these all appeared, they usually got put in because of a special, basically a special amendment by a particular legislator, or they were looked at as areas where, firearms should just not be allowed for philosophical reasons. Now, obviously, things have changed in the last 22 years. You are right. Churches are a target, I would say more so a target in our politically and religiously charged times today than they were back in the past. I think that there was sort of maybe a gentleman's agreement or honor among thieves or whatever you may call it, that churches were generally looked at as just sort of neutral ground. You didn't rob churches, you didn't commit acts of violence at churches. There was still sort of a chivalrous tone to outlaw activity. And so nobody would contemplate a church being a place of violence. However, in today's world, that's all out the window. As we know, there is no place off limits to a deranged individual who has a firearm. And that's why people should realize that really no place is quote unquote safe. Right. And that ultimately, at the end of the day, you're responsible for your own safety.
Edwin Walker, independent program attorney, U.S. and Texas LawShield. We're live on Facebook Live. Keep the questions coming in. Now, let's get to the other side of the story. People who are against the Second Amendment, who don't like that particular part of the Bill of Rights, will say, well, we need more laws. Let's just flat right out. He was court-martialed in 2014, the gunman, on 2 counts of assault with the spouse and the child. So he was a felon. He was a bad guy. As the laws right now would say that he wouldn't legally be entitled to have guns on him.
Well, he wasn't. I don't believe he was a felon. I haven't seen anything with that. I do know that he, under military law, he was convicted of committing an act of family violence, which does disqualify him under federal law, under both 18 U.S.C. 922D, he could not be sold a gun, and under 18 U.S.C. 922G, he could not possess a gun lawfully. And in fact, under Texas state law, if he was a person who had been convicted of domestic violence, he was also prohibited from possessing a firearm under Texas Penal Code 46.04. So he was already breaking the law by having the gun. Whoever sold him the gun, if they knew that he was prohibited and sold it to him, they would be breaking the law. The only way that he could have lawfully gotten a gun from an FFL is if there was some sort of flaw in the NICS system, which is run by the federal government and which is the system that all of the anti-gun folks who tell us that we're supposed to trust. So they want to, these anti-gun folks, they want to subject more people to the NICS system, or they keep coming up with other categories of folks that they want to be disqualified, like people who are on the no-fly list and people who have been investigated for unspecified acts of terrorism. These folks, where you don't really have due process, they want them to be on the NICS, but the NICS itself is, in some cases, not that reliable. And, I'm waiting to see more of the facts that come out on this. Also, another thing I want to throw out there for you is I've seen stories that say that he was dishonorably discharged, and I've seen stories that say that he was discharged for bad conduct. And that's actually a very important distinction, because federal law is very clear, and that if somebody is dishonorably discharged from the military, they go on that list of disqualified individuals forever and ever and ever.
So bottom line is, Edwin Walker is our independent program attorney. There's already a long list of things where this guy went wrong. He wasn't supposed to be in possession legally of a firearm, and he was. When he like flat out, that's how the conversation starts. He also, it says that he was using a Ruger AR-556, a type of an AR-15. If he goes to a store, do they do a background check when he goes to buy it from a regular, retail outlet, sir?
Yes, if he's buying it from a business that sells firearms as part of their business, they sell them commercially, then they are required to be licensed by the ATF. They're required to have a federal firearms license, and it is against the law for anybody who is licensed to sell a firearm to give a firearm to somebody that they do not run a background check on.
Okay, so let's say he's got a neighbor, Bob, and his neighbor has the Ruger AR-556, and Bob needs a little extra money. He says, hey, weird, guy who ends up shooting up the church, I'll sell it to you. Is there an obligation by neighbor Bob before he sells the gun to this gentleman who just thinks, I don't know, I didn't know he had any kind of criminal history? What's the story there when I just sell you a gun and I didn't know that you had been, court-martialed?
Well, if it is an intrastate transfer of firearm, that means between two individuals who reside in the same state, then constitutionally that is not a regulated sale in that it's intrastate. And so the U.S. Congress can't regulate commercial activity that's intrastate. Or personal activity that's intrastate. That violates the Commerce Clause of the U.S. Constitution. Now, if his neighbor had any way of knowing that he was a prohibited person, then his neighbor could be violating the law under state law. So Texas law does have a law that says you cannot knowingly transfer a firearm to somebody that you know is going to commit a criminal act with it, or who you know is a felon, or who you know is under a protective order, or who you know is from out of state, or you know is somebody who's been convicted of domestic violence. And so let's take the extreme examples. If you went to his neighbor and said, I really want a firearm, and I couldn't get one from the store, well, then the neighbor already now knows that he somehow is prohibited from getting one from an FFL. If he further goes on and says, I'm just so angry, I'm going to shoot up a church with it on Sunday, and the neighbor goes, oh, okay, well, I need money, so I'll go ahead and sell it to you. The neighbor himself has committed a criminal act. So this activity, while it's not regulated on the federal level, and this is one of the areas where the gun control folks said, we need national background checks for every transfer. Well, those people don't know much about the Interstate Commerce Clause because it does violate the Constitution. If you're doing it as a commercial activity, it's regulated. If you're doing it with people, if you want to sell to somebody across state lines, it's regulated. So, like I said, only that private, non-commercial transfer of a firearm between individuals of the same state is not subject to a background check. But, like I said, Texas law steps in and says if you know this guy is not supposed to have it, right, then you're violating Texas law by selling it to him. Stand
by. Edwin Walker, independent program attorney, U.S. and Texas LawShield. I'm going to get to the questions on Facebook as people are typing them in as quickly as we're talking. Okay, let's see. Derek, this is on Facebook Live right now. Derek typed in this comment. If I carry concealed, even though I have a CHL, and I have to use the gun against a shooter, what would happen if I had to use it to protect myself and others at a church that displayed both the 30-06 and 30-07 signs outside? So he's got the 30-06 and 30-07 signs that say no concealed, no open carry. This gentleman still brings his gun in. A bad guy shows up, and our gun holder, takes him out. Should he worry about being the good guy who broke the law?
Well, that's actually a great question because the law does provide some latitude here. Most specifically, he could always have in the event that they did charge him with a Class A misdemeanor because he brought his gun into a church after being given a criminal trespass warning that he was not supposed to, which is a Class A because it's still under Texas Penal Code 46035 and not strictly under 30-06 or 30-07. So if that happened to him, he would be able to allege the defense of necessity. And the defense of necessity says that it is okay to break one law if you are preventing a greater harm than the law you broke was trying to prevent. And so obviously preventing a murder is much more severe than a criminal trespass. And so therefore you would allege that. Now, he would have that defense if he went out and got his gun and brought it into the church in response to the shooting. If he just brings it into the church as a matter of as just his matter of habit, that's certainly not something he would want to admit to. And he possibly could be prosecuted for that without having the defense of necessity. It's very doubtful that he would be, looking at the practical application of the situation. But also it's very important to remember that just because you've committed a crime like a criminal trespass doesn't mean you lose your right to self-defense or defend others. You may lose a legal presumption that exists under the law, but you don't lose you always have your right to self-defense.
This is good stuff. Edwin Walker, independent program attorney. I'm Sam Malone. We're on Facebook Live with U.S. and Texas LawShield. Let's get to the topic of the good guy across the street, the Stephen Williford, 55 years old, who got out his gun and started shooting and obviously hit the bad guy, hit the gunman, Devin Patrick Kelly. What if the good guy misses? We've talked about this before. You hear shots fired. You're like, what's going on? You grab your AR. You go outside. You are pretty sure you got a good shot, good clear shot, and you miss, and gosh forbid you hit somebody. Let's talk about good guys who shoot at bad guys and miss. What's the liability? What's the legal angle?
Yeah, and that's actually a great question as well, because Texas has a very unique law in that it says that basically, with regard to injuries to what the law calls an innocent third party, somebody is liable if they recklessly injure an innocent third party or they intentionally injure an innocent third party, but they are not liable if they negligently injure an innocent third party. And so that means that that it was just simply a bad job of aiming, or their gun slipped or something. It was a completely unintended act that the innocent third party got injured. And so that's why, a lot of times there is a lot of difficulty in trying to make a distinction between a reckless act and a negligent act. So a negligent act is where nobody would have anticipated that the innocent party would have been injured. It was just purely an accident. A reckless act is where the individual comprehends that there is a risk to an innocent third party, but goes ahead and commits to the act himself. So, for example, if the individual was using a human shield, so the bad guy is using a human shield, the hero or the good guy with a gun decides to go ahead and just, spray the entire area, human shield and all, that definitely could be characterized as a reckless act. And so they could be liable for injuries or crimes that are committed in that reckless act. But if it was just purely a shot and he ducked out of the way, or I'm just a bad shot, or, somehow my arm got bumped and it went off in this other direction, that's an act of negligence. Generally, there's no criminal liability for that, but there could, of course, be civil liability for that.
All right. Edwin Walker with us. You are walking up to a church, and there is no 30-06 or 30-7 sign, and you carry all the time like we all do. What's the first thing that goes through your mind? You're not supposed to. Churches were, remember, listed when it first came out under the CHL rules in the 90s, but there's no signage. Walk in with your gun on under your jacket?
Perfectly legal.
Okay.
Yeah, and that's what a lot of people get confused about that, and it's because the legislature tried to fix the problem, but then just made it a little more confusing. Legally, it is fixed. So yes, legally, if a license holder goes into a church with their handgun, they are not breaking the law unless they've been given notice. However, when the legislature tried to fix this in '97, when they tried to go from churches being totally prohibited to churches being allowed to decide whether or not they're prohibited, they didn't really alter the main law. They just simply stuck another provision onto the tail end of the existing law. And most folks who read the law, who read Texas Penal Code 46035, don't ever get that far in the code. And they should continue reading all the way down to subsection I, and then that's whenever this exception is explained out to them.
Got it. And finally, Edwin Walker, because I know you're busy, I'm taking a half hour of your time here. If you are the good guy and you fire off a round or two and stop the bad guy, and the police come and want to talk to you, is it okay to call you first before you say anything? Is it you're like, oh my gosh, are you the guy who shot the bad guy? We want to talk to you. Is it okay to go, hang on 1 second, let me call U.S. and Texas LawShield, or do you talk to the police first?
Yes, absolutely. It is absolutely okay to speak to legal counsel before making any such statements, and it's obviously very helpful. That's what we tell all of our members. We tell them that if in the event they've been involved in a use of force or deadly force situation, they need to call 911 and report the crime that was committed against them first. Give the 911 operator their description, their name, their location, the crime that's being committed against them. But then to hang up, call their Texas LawShield program attorney, and then they will be given, the lawyer will counsel them. Their story may be 100% perfect, and the lawyer would say, look, tell the police exactly what you told me, exactly as you said it. There may be other areas of their story where they're not confused. Where they're confused, where they don't have all the facts, where they maybe are a little hazy on something. And at that point, they would be counseled to say, look, just tell the police the things you absolutely remember. Don't get sidetracked by things that you don't remember quite clearly, and in fact may actually be errors, because you will always have an opportunity to make another statement. You just don't want to make a statement that contradicts a statement that you had previously given.
All right, and that's great to know. You always say, gosh forbid you're in that situation, you're that good guy across the street who fires the shot that may stop the bad guy. It's perfectly okay, perfectly legal, and I guess encouraged to go, hang on, call 911, but then say, officers, hold on a second. Doot, 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 doot. Texas LawShield, yeah, here's my member number. I need to talk to the attorney on duty, and there'll be attorneys on duty. Because at least it's peace of mind. I can imagine, you're going in hyperspeed here, getting tunnel vision, and the anxiety skyrocketing. And even though you did the good thing and the right thing, consult one of the attorneys with the U.S. and Texas LawShield, and then sit and talk with the police, right?
Yeah, and a lot of people need to realize how important that is, because we've had situations where we've actually been a party to the conversation with the police while on the telephone. We've had situations where the lawyers have actually talked to the police on the telephone. We've had situations where the lawyers have listened to the entire conversation on the phone. So people should realize that, that a telephone is a lot quicker than any other possible way that an attorney could get to them. And just because it's on the phone does not mean that it's not effective. It is, in fact, very effective to have their lawyer on the phone.
It's got to be incredibly reassuring once you become a member to know that there's a legal team standing by to help you, protect you, walk you through it, whatever the scenario is, that you'll have instant access. Whether it's Monday morning or Saturday night, you'll have instant access to an attorney with U.S. and Texas LawShield. I appreciate you taking time to join us. This is independent program attorney Edwin Walker.